All right, the jury is deliberating, and I have two guests with us to help break all this down. Welcome to both of you. First of all, Jennifer Wells, a prosecutor, former U.S. attorney. Also, Tammy Allison, a former DOJ senior attorney. Listen, every state's a little bit different when we get to the sentencing phase. And we know in West Virginia, as I previously mentioned, that this is what's called the mercy phase. And the jury has to go back and make a unanimous decision as to mercy or no mercy for this defendant after convicting him of first-degree murder. Jennifer, if I could start with you, talk to me a little bit about, the state's position of we are going to ask for no mercy, meaning he will serve life without parole, from your perspective.
Sure. Well, what I think is fascinating about West Virginia is you heard the judge's instruction to the jury. One, they can consider all the evidence from the underlying trial, and including the mercy portion of the trial. Additionally, West Virginia law is explicit. The judge cannot tell them anything about what they're to consider and what they're not to consider, which is unusual. Usually, for example, in a death penalty sentencing in South Carolina, you have mitigating circumstances that are statutorily laid out, and those are things the jury could consider when deciding not to impose a death penalty sentence. Here, the jury is completely on their own, which is an unusual place to be, I think, for a jury to not have a whole lot of guidance. Usually when our jurors get very little guidance, they come back and ask for guidance. So that'll be interesting to see how that plays out. But I think from the states, what I think is really interesting from the state's perspective is that there's obviously some sort of forgiveness or love or some sort of understanding between these families where they've shown each other an incredible amount of grace. And I think that'll be interesting to see from the state's perspective how that plays out in this mercy portion of the mercy sentencing portion of this trial. I thought that was probably the most moving moment of the entire hearing, was when the defendant's mother and the victim's mother were embracing. The judge gave them a whole lot of leniency. A lot of judges would have said, absolutely not, y'all, no ma'am, y'all sit down. And he let that play out in front of the jury, and I'll be interested to see if that plays into the jury's decision to grant mercy in this case.
That's right. And Jennifer, one other thing I noticed the judge said was neither side has a burden of proof, right? So in addition to what you pointed out of, listen, you can consider anything, they also said, well, there's no burden of proof. So really, I think it feels to me more like the jury gets to decide based on how they feel about the case, whether or not he gets mercy. So as to, I think the defense was brilliant, Tammy, because after that played out as described by Jennifer, and the victim's mother actually hugged the defendant's mother, and then we saw on camera also was then hugging the defendant's sister, after that, I felt like the defense attorney regrouped and said, all right, just like they're starting this healing process, grant my client mercy so that can continue.
Yes, the defense attorney was brilliant when he brought that back together. And at my role at DOJ, in addition to being a federal prosecutor, I spent the majority of my time actually at the Office of the Pardon Attorney with clemency, federal executive clemency, which is kind of what West Virginia does here, that forgiveness aspect, which is really strange because typically you hear these things post-conviction where the evidence of forgiveness, so to speak, is being put before the court or individuals that are going to be able to decide that mercy or forgiveness. We see that with clemency typically, but in West Virginia, like we've already stated, it's very rare that the jury is the one that's going to make a decision prior to the sentencing phase of whether or not this defendant is going to serve life or life with parole coming up in 15 years. I do think that because of the lack of ownership of Mr. Lilly and not accepting responsibility, I do think that's going to hurt the case. And as good as his attorney was with bringing out the fact that the healing process has begun, I do think that the jury is going to recognize and always remember the fact that he has not accepted responsibility.
And let me ask you this, Tammy, because when you talk about your clemency work and the forgiveness aspect, are you surprised that the state didn't say anything about the judge letting all of that play out between the two families? Clearly, mercy, grace, forgiveness going on there right in front of the jury. Are you surprised the state didn't comment on that during this phase?
Yes, I am surprised because I always say clemency through ownership, and that ownership aspect is literal and figurative. Accepting of responsibility, literally accepting the fact that this is what happened. The families have come together. The prosecution should have brought that out, but then went ahead and made a stronger argument against that literal fact that figuratively what is happening here is yes, the families have come together, but the punishment aspect has not been met. The punishment still needs to go forward. And I do believe the prosecution could have made a stronger argument for the jury not to consider mercy by highlighting the fact that not only, as the prosecution did do, his priors from 2009, the sexual abuse case, but also attempting to run somebody over, but the fact that has a propensity for violence, and as we know, that's a term of art in the criminal justice world. I do think that the prosecutor could have done a better job of still highlighting, taking ownership, accepting that the fact that the families have forgiven each other, or at least are working towards it.
And Jennifer, I know that you are death penalty qualified in South Carolina. I recognize this was not a death penalty case, but having said that, what was your takeaway, if you have one, about the fact that we know this defendant testified in his own trial? He claimed it was self-defense. He was then convicted of first-degree murder earlier this afternoon, and he did not choose to testify or speak on this piece of mercy to the jury.
Sure, I think that that is actually a really wise call by the defense, and I'll tell you why. It's because I have seen that backfire in cases, in death penalty cases, as a matter of fact, where the defendant is given the opportunity to speak to the jury, basically to plead for his or her own life, and then the jury finds the words of the defendant to be frightening or offensive or something, and then it really works to the defendant's detriment. I think the defense counsel and the defendant's strategy to put mom and dad and sister on the stand was probably a better way to handle it. I think, one, no one knows your client better than you do, I would hope at this point. So I'm sure that was absolutely part of the conversation. But again, I think that it could have backfired here, even though he did testify. And the jury's had an opportunity to see him, to evaluate how they feel about him. Probably better to let the family make that plea at this point.
And so here we see him, and I just love the producers have been showing him seated there, because for the duration of the mercy phase, this is how he seems to have appeared. We didn't see him every minute of this phase, but we saw him pretty often. And he appeared to be like this, looking down. I didn't notice any tears or emotion on his face, in contrast to the family members who testified on both sides. Lots of tears. The victim's mother said, "My life's never going to be the same. He called me every morning and checked on me. My life's never going to be the same." And then the defendant's family apologizing and saying they were so sorry, and their condolences to the victim's family, and have mercy on our son. I'm sorry this happened to the victim's family, but we're asking you for mercy on our son, who we love and has always been a good boy. But yet, the jury is also watching the defendant. So, Tammy, if I could start with you. In jury trials in general, in your experience, how much weight does it carry for the jury to watch the demeanor of the defendant?
It carries so much weight. It shows if the defendant has atoned for his offense conduct. The only time that I saw this defendant show any type of emotion was when his sister was testifying and she was crying. He did put his head down, but there were no tears. There was no sense of remorse. And towards the end, whenever the prosecution had wrapped up, you saw him playing with his shirt, his arms up over behind his head, just very nonchalant to what's going on. I think the jury is paying attention to all of this, no matter how much the families may have mended and be working towards forgiveness, right? The jury is still paying attention to every little move that he's making. So I do think that the jury has a really tough call here, and it may be a situation like what happened last month in the case of Shondarius, Reader, where the jury could not make a decision as far as mercy. And in West Virginia, there is no case law as to what happens when the jury cannot make a decision. And the judge referred it to the Supreme Court of West Virginia, and that's currently pending. So I'd be interested to see what's going to happen moving forward.